if the Taiwan Constitutional Court finds the death penalty per se unconstitutional, my prediction and my analysis of the nature of the issue predict that there will be serious political consequences. And I advised in my expert opinion that the Constitutional Court not find the death penalty per se unconstitutional, but there are other institutional alternatives that the court can consider.
According to a social opinion survey conducted by Academia Sinica in 1990, 75% of the Taiwanese public was against abolishing the death penalty, and only 9% supported its abolition. 30 years later, the trend has not changed. A 2022 poll by the Foundation for the People showed 86.9% against abolition and only 12.4% in favor. A 2023 news outlet ET Today's poll showed that 73.5% against and 21.8% in favor of abolition. Over nearly 35 years, the trend in Taiwanese public opinion on the issue of death penalty has remained fairly stable, with a consistent 70% to 80% opposing its abolition. Against this backdrop, the Constitutional Court is charged with determining the constitutionality of the death penalty and is expected to issue a ruling on the legitimacy of capital punishment in the following months. Given the strong public support for maintaining the death penalty, it remains to be seen how the Constitutional Court will rule. However, the impact of its decision will undoubtedly ripple through society. My name is Iris Xu. You are listening to The Divide.
Recently, there has been discussion in society about the 3 constitutional interpretations related to the death penalty in the past. Therefore, these 3 interpretations, having been done 3 times, should already be stable perspectives. The Grand Justices should not handle this constitutional interpretation case, nor should they provide an interpretation. This matter should be left to the elected representatives to decide.
As discussions and debates surrounding the death penalty continues to boil due to the Constitutional Court's involvement, it turns out that this isn't the first time the court steps in on this issue. And here's Executive Director of Taiwan Alliance to End the Death Penalty, Lin Hsin-yi.
However, those who discuss this issue either ignore or intentionally avoid mentioning what the content of the 3 previous constitutional interpretations related to the death penalty was. These 3 interpretations, the earliest of which was in 1985, were actually made during the period of martial law in the authoritarian era. The first recent one was in 1999, before Taiwan's democratic transition in 2000. So you can see that these interpretations were made by the Grand Justices of Taiwan before the democratic transition or during the authoritarian era. What was the content of their interpretations? The first interpretation stated that the crime of drug trafficking could be punished by the death penalty. For second, crimes like treason or kidnapping for ransom, even if no one is harmed, can be punished by the death penalty. Or thirdly, they said that drug-related crimes could be sentenced to death. So you can see that the constitutional interpretations made in the past all say that even if you haven't committed murder, you can still be sentenced to death penalty for such crimes. Speaking of an eye for an eye, honestly, even if you support that concept, I believe that the constitutional judgments made at that time would be unacceptable to most people. However, considering that many years have passed, possibly 3 or 4 decades, Taiwan's democracy has progressed, human rights have advanced, and international norms have changed. At this point, it's reasonable to consider whether Taiwan should have the death penalty system.
Despite Lin's enthusiasm, there's another voice that's arguing against the court taking on the case.
My name is Jimmy Chia-Shin Hsu. I'm a research professor at the Institute of Law, Academia Sinica, Taiwan. I am one of the experts that have been requested by the Taiwan Constitutional Court to offer our expert opinions on the issue of the constitutionality of the death penalty in Taiwan. And basically, my position is that the constitutionality of death penalty in Taiwan has multiple layers of issues. So the first issue is whether the death penalty per se, in and of itself, is constitutional. And the second layer of issues are whether the particular provisions in the criminal statutes are constitutional. So, for example, the criminal offense of murder or murder plus hijacking or murder plus rape, whether these provisions in the constitutional statute, in the criminal code are constitutional. And these issues should not be confused with another very important issue, which is whether we are going to abolish the death penalty. These are very different levels of questions. So even if you find the Taiwan's death penalty constitutional, even if the court find it constitutional, says it's okay, the legislature can still go ahead and make reforms or even abolish the death penalty. So the issue is whether right now it should be up to the Taiwan Constitutional Court to make the decision, the final decision. And my stance is that if the Taiwan Constitutional Court finds the death penalty per se unconstitutional, my prediction and my analysis of the nature of the issue predict that there will be serious political consequences. And I advised in my expert opinion that the Constitutional Court not find the death penalty per se unconstitutional, but there are other institutional alternatives that the court can consider.
Professor Jimmy Chia is one of the experts the Constitutional Court invited to give experts' opinion on the death penalty's constitutionality. And interestingly, he is not arguing for the death penalty. He is arguing against the court making its final decision on whether the death penalty is constitutional or unconstitutional. After the Constitutional Court debates, many news reports came out labeling Professor Hsu as a supporter of the death penalty.
That is a rather inaccurate description of my position. My position, I understand, is hard to just, to boil down in just one sentence, and it's not good for media reportage. But my stance has basically two dimensions. One dimension is whether and what kind of decision is appropriate for the Taiwan Constitutional Court to make. And the other dimension is whether the death penalty in Taiwan should be reformed or should be kept or simply should be maintained. And that is another dimension. But in my expert opinion, I'm making the stance that this issue is so complicated and it involves, a very serious clash of two value systems between the abolition thoughts that Taiwan has been receiving for the past 20 or so years, and the society's traditions at large. So these two value systems clash for the moment in an irreconcilable ways, and it would be very politically dangerous even for the judiciary to just find it totally unconstitutional and just wipe out this institution that has very deep root in Taiwanese society in a simple stroke. And I don't think that is a wise way to go about doing this, even if you want to abolish it.
As Professor Jimmy Chia-Shin breaks down his opinion, Here's Ms. Lin Hsin-yi's response to this particular argument.
那当然也有人，我刚才讲说，他们就说，那大法官不应该做决定，应该
Of course, there are also those who argue that the grand justices should not make the decision. It should be left to the legislative body. Public opinion or the legislature makes decisions because the majority of public opinion opposes abolishing the death penalty. I think it's unreasonable to say so. If you use that kind of reasoning, you might as well oppose the role of Chief Justice altogether. Under the framework of the separation of powers, the Chief Justice represents the Constitution and the Judiciary, so naturally each power should do its own job. I think the value of the Constitutional Court or the Chief Justice's interpretation lies in the fact that they are defenders of the constitutional or human rights values. Their original design, frankly speaking, is to resist majority opinion.
And here is Professor Jimmy Chia's response to that.
So this is called a counter-majority function of the courts, which means that if the court wants to protect individual rights, then sometimes you have to go against the majority opinion. But I think this function actually has a lot of nuances. So when the theory was first put forward by theorists, it was posed as a dilemma that is to be faced by the court. It's called the dilemma or the difficulty of counter-majority, of the court's counter-majority position, which means that there's a dilemma. On the one hand, the ultimate legitimacy of the court comes from the people through the Constitution that the people made. The court's authority comes from the people, first through the Constitution and through its interpretation of it. But ultimately, the Constitution comes from the people. And there's always a tension between what exactly the Constitution says and what the people now think. And so the court always have to negotiate with its own legitimacy. And so it's called democracy. I mean, democracy means that people make the final decision. And on the other hand, the court would definitely have to protect individual rights. So the difficulty or dilemma of the counter-majority means that while we give the court a tremendous amount of power to interpret the Constitution, the court, when it exercises such power, it has to be very careful in dealing with the majority, and especially when the majority opinion is stable, long-standing, and has its roots in current law, in current statutes. So that means the court, even if the court has the power, it has to be extra careful when exercising it. You can have the power, but you also have to have the wisdom of how to exercise it in order not to jeopardize your own standing as only one of the three branches of the government power. So I'm in the expert opinion, I'm calling for precisely based on the theory, or the understanding, a constitutional understanding, that the court sometimes would have to exercise judicial self-restraint. And on this issue, I think this is the issue that the court would have to exercise self-restraint to a certain extent. I'm not saying that the court should do nothing, cannot do anything, but I would urge the court to use extra caution. So I think because the court has, in the past decade or so, indeed, the court has turned down the cases, several times before. Maybe the court back then thought it wasn't time, the time wasn't ready. And this time, the court takes up the case. And when the court takes up the case, it is indeed telling the society that there is a chance that the court could strike it down in total. And so I wouldn't say that the court is not totally without legitimacy to take up this issue, because this is indeed a very important issue regarding the very rights to life of these convicts. And so I'm only urging the court that when it makes a decision, it use extra caution and perhaps try their best to find to find a ground in the middle. So on the one hand, it would urge the legislators to make some reform to the system, to the criminal law system, in order to avoid, so for example, wrongful conviction, or some, maybe if there is any arbitrariness in the sentencing, or any other flaws in the system. So I would be happy to see that the court used its power to push the society a little bit forward. But I would, on the other hand, I would also urge the court to leave some room for the society and for the legislature to make some decisions. So for example, do you want to leave the death penalty, reserve death penalty for crimes during the war? Or do you want to leave some most serious crimes such as genocide, crimes against humanity, or ethnic cleansing? Do you want to leave death penalty for these because it is allowed by the Rome statutes, which establishes the International Criminal Court? And there are many options in between. I'm only urging the court that do not just by one stroke, just rule out all these options that has not been contemplated by the legislature.
And here's Miss Lin Hsin-yi.
我觉得台湾现在最乱的地方就是在于，就是我们的立法院可能没办法好好运作。
I think the most chaotic aspect of Taiwan right now is that our legislative yuan might not be able to operate well, and politics is really difficult to handle properly. When our alliance to end the death penalty was established in the past, our advocacy target was indeed to urge the executive yuan and the legislative bodies to abolish the death penalty in Taiwan. Or perhaps because we had ratified international conventions, we should move towards abolishing the death penalty. However, you can see that over 20 years have passed and our political and legislative branches have not been able to make a decision. So, from this perspective, the willingness of the Grand Justices to accept such constitutional interpretations and make decisions is just right. It's within the framework of the separation of powers, and at this moment, I think it's the most appropriate way to handle it.
As Ms. Lin Hsin-yi and Professor Jimmy Chia-Shin both provide many compelling arguments from both sides, the Constitutional Court will have to come to a decision in the next 3 to 5 months. And while my two guests seem to disagree with each other on so many fronts, I was able to find a common ground between the arguments they represent.
This is definitely a very, very politicized issue. It's quite clear. But it's just as every important issue in the society. Whenever there is an issue that everybody cares about, it's got to be politicized, as a matter of fact. And because the political parties, the legislature, really sense that people care about it. But so is many other criminal issues, because criminal law by nature is in modern societies is one of the most evocative issues for a society, because it a crime, especially a serious crime, violates people's values, the most cherished values, and people feel very strongly about it. So it is very easily exploited by politicians. But I don't think that this is a good reason just to say, okay, then let's avoid politics, because democracy is about politics.
在很多过去的时候，我们
In many past cases, such as same-sex marriage or adultery, the majority of public opinion was actually opposed. However, after the interpretation, you will find that it doesn't seem to matter much, and then you have corresponding methods. In fact, Taiwan would be considered a more democratic and humane rights-respecting country.
更民主。 更人权的一个国家。好